Silicon Valley likes to celebrate the immigrant entrepreneurs. But what happens when that entrepreneur's company suddenly runs out of money, reconstructs, or removes the founder from the job? That is the concern behind another proposed DHS change. Immigrant founders have historically had to navigate very complicated rules around H-1B status, company ownership, and the employer-employee relationship. And now, according to TimesXP's report, recent USCIS modernization effort, it has created clearer pathway for some foreign entrepreneurs to build companies while maintaining status. But you know what? The proposed elimination of 60-day grace period, it could create a particularly difficult situation for all the founders because startups are unpredictable. A large corporation may have years of financial reserves. A startup may have just 3 months. One funding round can decide whether the company survives or not. One board meeting can change the CEO. One investor can walk away. And if the founder's immigration status it is tied to that company, a business crisis can quickly become an immigration crisis. In fact, the report also highlights several potential vulnerabilities, including venture capital reconstructing, funding delays, and questions around the employer-employee relationship required for certain H-1B arrangements. Well, that creates a very strange contradiction if you see. America wants entrepreneurs to build companies. It wants innovation, it wants investment, it wants startup creating jobs. But the immigration system also imposes strict conditions on how foreign founders can structure those businesses further. And you know what? That is why this particular debate, it is bigger than just one visa category. It is about whether immigration policy encourages immigrants' entrepreneurship as well, or makes the risk of entrepreneurship even higher for people who are already navigating a very complicated legal system. And yes, when policies are uncertain, entrepreneurs, they do not sit and wait. They organize, they speak out, they lobby, they prepare legal challenges, and that takes us to our next story. When policy is being written in Washington, the people affected by that policy are not necessarily staying silent. According to the reports acquired by TimesXP, a growing mobilization among South Asian community leaders, immigration advocates, lawyers, and technology workers around the proposed elimination of H-1B 60-day grace period. And the biggest weapon they are preparing to use is something very, very American: public comment. Ladies and gentlemen, when a general agency proposes a major regulation, there is generally a formal process through which members of the public, members of the companies and organization, they can submit their views. And those comments, they can really matters. Advocates are preparing argument around the practical reality of hiring. A technology company may need weeks to interview somebody. Then there are background checks, internal approvals, salary negotiation, immigration paperwork, and potentially additional processing time too. So, advocates argue that removing a transition period, it could make it extremely difficult for employers and workers to complete the process legally. In fact, they're also pushing an alternative idea here. Let me share it with you. Instead of eliminating the grace period, expand it from 60 days to 180 days. But yes, there is something very important to remember here. The proposal is not yet the final rule. Report says it remains an early review, and that existing 60-day protection, that remains operational. So this is a story about a potential future change and about people trying to influence that future before it becomes a law. And yes, that brings us to something fascinating. The same technology industry that is fighting to protect the immigrant pathways, it is also undergoing a massive transformation because of artificial intelligence.